Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
The arrest, paragraph 32. On the afternoon of 12 December 2023, as I was driving in Tuba area, I saw a car suspiciously following me very closely. The occupants of the car announced that they were police and that they wanted me to stop on the side of the road. Paragraph 33, I indeed stopped the car in full compliance with the instruction. They thereafter approached me and informed me that they were police. They further informed me that they were executing arrest upon me in connection with the death of Mr. William Kunene. Paragraph 34, after my arrest, they traveled with me from Tuba to Durban, ultimately arriving shortly before 1900 hours in an area called Isipingo, if I'm not mistaken. It was the end of the trip from rural Tuba area, but the beginning of my travel with and in the hands of the police. Paragraph 35, the assault upon me by the police started immediately. Though I had been told when arrested in Tuba that my arrest was connected with the death of Mr. William Kunene, I was greatly surprised that during this assault brought to bear by police upon me and also tubing me, they were demanding me to make a confession statement to the matter of a well-known musician, Mr. AKA, instead of Kunene matter for which I had been arrested. I denied steadfastly any involvement with the matter of Mr. AKA. Paragraph 36. Other than the denial of involvement in the matter of Mr. AKA, I never resisted arrest but cooperated fully with the police. I was thereafter detained from Tuesday, the 12th of December 2023, until I was granted 5,000 rand bail by the learned magistrate, Mr. Singh, in this very same court on 8 January 2023. In this regard, bail receipt is attached to the charge sheet, Exhibit A. Paragraph 37. Among the terms and conditions that the learned magistrate, Mr. Singh, prescribed for my release on bail was to report daily at my nearest police station, Mtuba. From date of my arrest from the date of my release on bail until the day of my arrest again on 27 February 2024, in connection with this matter, I have been fully complying with all bail terms and conditions. Moreover, I never fled despite knowing from the date of my arrest in the other matter in December 2024 that I was also being investigated by police in connection with Mr. AKA incident. Paragraph 38. Though I'm a layman, but after the assault by police that was intended to extort confession from me, I summarily reached a conclusion that the state is skating on a thin ice as it does not have evidence linking me to the offense or the offenses. Paragraph 39, I will plead not guilty during the trial proceedings and put the state to proof thereof. I'm willing, prepared, and ready to take this honorable court into my full confidence that I will be found not guilty if this matter proceeds to trial. Paragraph 40, in fact, I will instruct my legal team that this matter stops after the state case by applying for a discharge in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Paragraph 41. The reasons for asking for bail are as follows. 41.1. I have not been furnished with copies of the state witnesses' statements. Therefore, I do not know the identity of the witnesses, and in terms of Section 60, subsection 4C of the Act, will not intimidate or threaten any of the state witnesses. 41.2. I support my family and my siblings' kids financially. 41.3. My detention is really an anticipatory punishment as the state does not have evidence to sustain the charges. 41.4. I will stand trial in terms of Section 40B of the Act as I want to prove my innocence. I never fled even though I became aware of my possible arrest for this matter during my first arrest in December 2023. 41.5. I will comply with the conditions the court deems appropriate to accompany release on bail in accordance with Section 62 of the Act. 41.2. My release on bail will enable me to raise money to pay for the services of my lawyers. 41.8. My release on bail will also help me to help my wife finance loan facility she took for our house at my homestead. 41.9. It is my desire to support my wife during her pregnancy until she gives birth to the baby, and it is my wish to be also physically and emotionally present when the baby is born. 41.10. My release on bail will not endanger the safety of the public in terms of Section 60, subsection 4A of the Act. 41.11. I will not commit any offenses while on bail. 41.12. I will not undermine proper functioning of the criminal justice. 41.13. My release on bail will not disturb the public order or undermine the public peace or security. 42. Though my legal team has advised me that this honorable court has judicious discretion in respect of the terms, conditions, and amount in relation to bail, my wife has, however, raised an amount of 3,000 rand for bail. I must reiterate that my wife is the person who paid my 5,000 rand bail in the other matter. The strength of the state case, paragraph 43. Despite the fact that I'm a layman, my legal representatives have advised me that the state case is extremely weak despite long list of charges, and there is a strong view of splitting or duplication of charges. 43.1. Conspiracy to commit murder and murder, counts 1 and 2. My legal representatives have very strong, sound, and persuasive argument to present if and when this matter proceeds to trial, in that these two counts constitute splitting or duplication of charges. The learned author C.R. Snyman in criminal law clearly defines conspiracy as an inchoate, formally defined crime, whereas murder is a complete, materially defined crime. Hence, more often than not, the rule of practice is that the former is an alternative to the latter. 43.2. The charges of money laundering do not make legal sense, do not satisfy the legal requirements, and do not have the requisite points A, B, and C. For clarity's sake, point A is first point of origin of money, with point C as destination point, with point B as a laundering or washing or cleaning up point so that the dirty money reaches point C, looking clean or normal. Bizarrely, the charge sheet of money laundering in this matter do not have point A as a point of origin of payment, thereby making inference irresistible or inescapable that point A is just an innocent point. Therefore, money laundering charges will not stand the legal test in its current form during the trial proceedings. Put differently, I'm advised that even if my legal representative do not make an application for a discharge after the close of the state case in respect of these money laundering charges, the presiding judicial officer during trial proceedings will mero motu consider the discharge. 43.3, I was never found in physical possession of any firearms and ammunition. Therefore, my legal representatives will be able to persuade the judicial officer during the trial proceedings that the possession of firearms and ammunition alleged by the state in this matter does not satisfy the legal requirements. In other words, the possibility cannot be excluded that the presiding judicial officer during the trial proceedings will not agree with the state that it is the only inference to be drawn and an inference that excludes all other inferences.
Okay.